Hello and welcome to episode 3 of Plaintiff Prep. At this point, you've experienced a life-changing accident and you sought help from an attorney. You filled out an intake form and you spoke to the attorney about your accident during the initial legal consultation. Now, the attorney has agreed to take your case and you decided that this is the attorney for you. The next step is to sign an engagement agreement with the attorney, which creates the formal attorney-client relationship. In certain types of lawsuits, including personal injury claims, some attorneys will agree to take your case on a contingency fee basis. But what does this mean? The point of this video is to help you understand contingency fees. That way, you can be more comfortable when an attorney presents you with a contingency fee agreement. So, let's jump right into it.
Now, let's talk about contingency fees. Essentially, a contingency fee means that your lawyer doesn't get paid unless you get paid. More specifically, your lawyer agrees to represent you for a certain percentage of the total amount of your settlement or jury verdict. This also means that if there is no recovery, or in other words, if your attorney loses the case, you likely won't have to pay your attorney anything. So, how do we calculate contingency fees? Well, the allowable percentage is typically determined by the laws of the state where you're bringing your claim. For example, in Florida, contingency fees are limited to between 1/3 and 40% in personal injury cases, depending on what stage of litigation you're in.
Contingency fees can be a little different in medical and dental malpractice cases than in other types of cases. For example, Florida limits the percentage in med mal cases to 30% of the first $250,000 recovered and 10% of anything over that. However, Florida allows the client to waive this right in writing, which may give the attorney a bit more incentive to try and get you more money. It's important to note that the lawyer's fee percentage is based on the gross amount recovered, and so it does not include costs of litigation, like filing fees and expert witness fees. These costs are typically deducted from the client's percentage of the recovery.
Finally, once you sign the contingency agreement, you officially have an attorney representing you. Now, you and your attorney will be working together as a team to get you the money that you deserve. Thank you for joining us for another episode of Plaintiff Prep. Tune in next episode where we're going to be talking about the pre-suit investigation process.